The last set of crimes we're going to discuss pertain to both the federal and the state governments. These crimes focus on protecting the government's ability to carry out its functions of prosecuting and convicting criminals, as well as maintain the public's confidence in the U.S. legal system. Crimes committed against the administration of justice undermines and impedes the government from doing its job. These crimes include perjury, bribery, obstruction of justice, resisting arrest, escape, and contempt of court. We're going to start with perjury. Perjury in law, the law of perjury, the giving of false testimony under oath on an issue or point of inquiry regarded as material. Both the common law and modern federal and state legal systems have provisions for taking testimony under oath and mandate penalties for giving false testimony. Witness testimony is extremely important in a variety of settings: grand jury, trials, both civil and criminal. There's hearings, there's all sorts of judicial functions. The jury, and talking about jury trials, the juries rely on testimony, right, to make its decision. So do courts, so do judges if they're hearing a particular case. Perjury may be committed by witnesses from either the prosecution or the defense, or by witnesses on either side in a civil case. And in proceedings before the jury, or even after the verdict. Anything that is a legal proceeding that might lead to a sentencing or something prior to having trial. If somebody is going to be a witness in a judicial proceeding, they're going to have to be sworn in or be under oath, and they're going to testify. We're going to talk about the specific elements of this crime in a minute. The Model Penal Code defines perjury as a false material statement that the defendant does not believe to be true, made under oath in an official proceeding. New York's law is generally the same, and perjury is a felony. The grade is dependent on the official proceeding. To be guilty of perjury, an accused person must exhibit criminal intent, right? That mens rea. The person must make a false statement and must either know the statement be false or not believe it to be false. They make it recklessly. It must be under oath. What's under oath must be given by someone with the oath must be given by someone with legal authority to do so. A notary is somebody authorized to give an oath, a judge, a hearing examiner, a clerk of the court, an attorney in some instances. And the oath is, did you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Most of the time they're raising their right hand. They got their left hand on the Bible. That is giving an oath. In addition, the false statement. False statement can be written or it can be orally made. People who sign and make statements to law enforcement, statements are written out and then they sign. And there's a little oath that's on there that's administered by the law enforcement agent who has the authority to do so. And you sign. And if you wrote something in there that's false, you can be charged with making a false statement. Must be material to the matters at issue in the proceeding, meaning that the testimony substantially affects or could substantially affect the outcome of the proceeding. So, for example, an eyewitness to a murder. The testimony could affect the case. It hinges on identifying the murderer. And if that witness, he or she intentionally lies under oath, giving testimony about what they witnessed, then it's perjury. Crimes associated with perjury include subordination of perjury, and that's persuading other persons to commit perjury, or knowing of another's perjury and failing to make that information known to the authorities. Attorneys are required, if they know their client's going to take the stand and lie, the attorney is required to try to do something to not let that happen. Of course, an attorney can't get up and say, hey, my client's about to lie, because attorneys have an attorney-client privilege. Whatever that client tells an attorney, they can't tell anybody else. So attorneys are trained in a way that they're alerting the judge to the fact that somebody's about to commit perjury if it's their client. So there's a wide variety of statutory offenses involving making false statements in official documents, such as when you apply for a driver's license. How about if you apply for financial aid? I'm sure when you sign the bottom, there's a little oath there that the statements you're making are true. So there's a number of official documents that, if made falsely, the charge might not be the term perjury, because that has to happen at an official proceeding, but you can be charged with making a false statement or fraud, something of that nature. So a person who makes a false statement but later corrects it has not committed perjury, but that retraction must happen within the course of the same proceeding in which the false statement was made. In many jurisdictions, the law imposes special requirements for the proof of perjury. One such requirement is that a person cannot be convicted of perjury on the testimony of only one person, kind of like treason, meaning there needs to be corroboration or some additional evidence, and it's usually in the form of another witness. Some famous examples of perjury convictions: former pitcher Roger Clemens was indicted and charged with perjury for allegedly lying during a 2008 congressional hearing on performance-enhancing drugs. 2001, the rapper Little Kim witnessed a heated gunfight outside a New York radio station, Hot 97. The shootout between Kim's entourage and the rival rap group included over 24 shots fired. When a federal grand jury called Little Kim to testify about what she had seen during the firefight, she claimed not to have noticed her manager and another member of her entourage at the scene. The false testimony might have worked if not for security camera footage that showed one of the men in question actually holding a door open for her. In 2005, she was convicted of 3 counts of perjury and 1 count of conspiracy in connection to her fabricated testimony. She actually received a sentence of 1 year and 1 day in prison and a $5,000 fine. That was a federal charge, by the way, federal. If you watch the O.J. Simpson trial at all, or if you know about it, one of the LAPD detectives, Mark Furman, provided key testimony in that unsuccessful prosecution. One of the key sticking points in the trial was whether or not the detective had habitually used a variety of racial slurs with colleagues and suspects. And he vehemently denied those charges. But Simpson's defense team was able to turn up multiple witnesses and tapes of him spewing all sorts of hateful slurs, which really hurt his credibility. But he was also charged with perjury. He was the only one who was convicted of a crime out of that trial. So, perjury. And then our next crime is bribery. There are 3 types of bribery: bribing public officials, engaging in commercial bribery, and bribery of foreign officials. And that's a federal crime, foreign officials. So let's talk about public officials. This is an attempt to influence a public official to act in a way that serves a private interest. That's a crime. So anything the recipient considers to be of value is something of interest. So the question is, who is a public official? Could be an elected officer, could be an appointed officer to a government seat, could be, city mayor, or city council or mayor, could be the district attorney, could be a judge. So public official. When does the crime take place? Time of the bribe, or after it's completed. If it's after completed, then both sides can be arrested for bribery. So if somebody was to pay off the judge to give somebody a lenient sentence, and the judge accepts, the person who made or solicited or made the bribe, can be arrested for bribery, and the judge can too for accepting it. But if the judge doesn't accept it, then the person who made the bribe can be charged. There is commercial bribery. This is done usually to obtain proprietary information or cover up an inferior product, or secure a new business. It's used in the business world. So, for example, Rosemary works for Telcom. She offers Craig, an employee at QMC Services, which is a competitor of Telcom's, a payoff in exchange for KMC's trade secrets. That would be an example of commercial bribery. Kickbacks, payoffs for special favors or services, those all count. What about our foreign officials? Basically, it's just like the public officials, except we're dealing with foreign officials, or officials that are outside of the U.S., doing so to obtain favorable business contracts. This law is under the Foreign Corrupt Practices Act in the federal law, where a individual is bribing a foreign official just so they can get a leg up with business contracts overseas, for example. Generally, there is no defense to bribery. The crime happens when solicited or offered. Doesn't need to be accepted, even if the person solicited has no authority. So even if somebody made a bribe to somebody and then it comes out that they couldn't make that happen, that bribe happen, because they had no authority, doesn't matter. As long as the intent to procure a private benefit as a result of the bribe, it's a crime. Obviously, it can be hard to prove unless you got, a recording. It would be one person's word against another's. For example, here's an example of bribery. Joe is a property owner and a commercial contractor who wants to put up a business in a town. He has to get a permit and get permission that meets building codes. He offers Sally, who is a zoning board member and who has a lot of influence with the other board members, $10,000 to vote to pass the construction and help get the others to follow suit. That would be a bribery. That would be a bribe, and that would be a charge of bribery. And it's a felony, and it's in New York, it's graded, and with enhancements for the bribery getting harsher the larger the bribe. So it is a crime of bribery in New York. If the bribe results in somebody's prosecution or incarceration, that's a higher level felony. So this is trying to bribe the DA or the judges, or maybe trying to pay off or bribe a law enforcement agent if it involves someone's prosecution and or incarceration. Bribery is a felony. There's a low level felony. It's D, which is just making a bribe. $5,000, if the bribe involves $5,000 or more, it's a C felony. If it's $100,000 or more, it's a B felony. And if it's used to influence prosecution or a sentence, that's also a B felony. So it's very serious business, bribery. And this is under state, those were under New York State bribery laws. Obstruction of justice. In New York, it's called obstruction of governmental administration. It is a misdemeanor. Other jurisdictions recognize it as a felony, depending on the type of obstruction. It's only a misdemeanor in New York. It's the crime or act of intentionally or knowingly interfering with the process of justice and law, especially by influencing, threatening, harming, or impeding a witness, potential witness, a juror, or judicial or legal officer, or by furnishing false information in or otherwise impeding an investigation or legal process. So it's a whole lot of things, right? There's many forms. Giving the police false identification, refusing to give evidence, giving a false statement, whether you're under oath or not. If you're not under oath and you give a false statement, you could be obstructing justice. Barry Bonds, an example in the reading material. He was charged with perjury and obstructing. I represented a woman who stood on top of a cop car so her boyfriend could get away. What was she doing? She was trying to prevent them from going after her boyfriend. She even laid in front of their car so they couldn't drive away. Hiding out somebody that may have a warrant against them could get you an obstruction of justice charge, could get you accessory, depending on the circumstances. We've talked about accessory. So obstruction of justice can certainly be very broad and constitute a lot of conduct. And it is broadly used. Some additional crimes, another broad crime, resisting arrest. In New York, it's a misdemeanor. And it is very broad. Running away from the police while they are trying to procure your arrest. Pulling your arm away while they're attempting to put handcuffs on have been deemed resisting arrest. Not putting your hands where they're supposed to be. Struggling. All of these things. Or stepping away. You don't even have to run away. The police tried to tell you to turn around, put your hands on your head, and you start stepping backwards. That could be considered as a resisting. Escape. There's many graded levels on escape. The misdemeanor level of escape is that you try to get away after being in custody, quote unquote, in custody. So let's say someone was arrested. Let's say the cops pull over somebody and they can't drive. Driving without a license. The license is suspended or revoked. That's a misdemeanor charge. So the cops ask the individual to get out of the car, hands behind your back. They put handcuffs on them, and while they're trying to put the person in their cop car, the person gets away and runs off. That could be escape because now they're in custody. And then there's escape for folks who are convicted. And there's 2 levels, and it depends on which type of crime you're convicted for. If you're convicted for murder and you escape from prison, that's a pretty high level escape charge. If you are convicted of let's say a low level felony and you're in a detention center and you escape, it's a lower level felony, but nonetheless it's still a felony if you are convicted of a felony and you try to break away from you do break away from a detention facility. Even if you walk away, oh look, they left the door open, and you walk out, it's still going to be considered escape because you're supposed to be detained. Criminal or contempt of court is also known as criminal contempt. In New York, we shorten it as criminal contempt. This is disobeying a court order. And these primarily include restraining orders. When courts issue restraining orders for people to stay away from other people, that would be a criminal contempt. In the case of a grand jury, testifying against a grand jury, and you refuse, there's usually some steps that have to go along with it before you get a criminal charge. You usually get some sort of warning, and then if you persist, then you can get a criminal charge of criminal contempt. And they are graded as well, depending on if we're talking about the restraining order situation, which is most of the time what we're talking about in New York is a criminal contempt. It depends on who the victim is. If they're related to the offender or not, it elevates it. If the victim is a family member. Depends on the harm that's caused as a result. Let's see, other instances. Yes, avoiding court orders by not testifying when you're supposed to at a hearing, trial, or grand jury. It's another avenue of the criminal contempt or the contempt of court. So that is it. Those are all the crimes against the government, and that completes the materials for the course.